Good evening. You are with the Urban Debate here. I'm Sahar Zaman. We at Mirror Now have been talking about protecting Mumbai's green lungs for weeks on Mirror Now. To stop 2,700 trees from being massacred, chopped off in Aarey. But this people's movement is not just about one forest or one tree. This is how environmental issues should be fought by each one of us in each of our own cities. Why is the government not listening? Why is the government not looking at other alternatives? Today, in the Aarey case, the Mumbai City Body Chief, the BMC Chief Praveen Pardeshi, along with Mumbai Metro Railway Corporation Managing Director Ashwini Bhide, reached out to activists, and this was in a bid to allay their fears about the damage to the environment. Were the activists convinced? Not exactly. Not by the government's pro-development pitch. On the other hand, the government already making it very clear that they are against the relocation of the project simply because there are no options. And we should make this, if you want to call it a sacrifice, for the name of development. Let's take a listen into some of those reactions that have come in from today's meeting.
This is higher than any other large metropolitan. That's the number of trees in Mumbai compared to any one of these. Another thing which I want to tell the students of, no other city in the world has a national park which actually people like Devi Goenka and all have been able to protect with its current boundaries, which is not a forest as we think about it. We have floods in Mumbai, isn't it? But is the car shed built already? So are the floods being caused by the car shed?
It's already built, sir.
Yeah. So then we don't need to do anything more. You can start your car depot operations. In a city which has got a continuous, smooth, cheap public transport, people can have homes much further away and still reach their workplaces. One of the great achievements of your campaign to save Aarey is generated so much of a counter narrative which I wasn't aware of at all. So that's why I felt so. A lot of the stuff out here is not coming from their official records. It's coming from crowd.
All right, let's get in further inputs here from our correspondent. Before we throw this open to our panelists here tonight, we have with us our correspondent Amita getting us those details here. Amita, it seems like this town hall was more about convincing people on how beneficial in terms of development, public transport, the coming of the metro, the construction of the metro car shed is going to be there. Has it directly addressed the damage to the environment, irrespective of the benefits of the metro that are already known, that we know of? But it is at the cost of the environment. It is the cost of losing heritage trees forever.
Well, that's correct. And the line that the government is taking at this point is that X number of trees will be transplanted, that new plantation will take place, and that the government has already planted 33 crore trees. And that is something that the government has been saying, that development has to happen. And this is the only area where development can in fact happen, where the car shed can in fact come up. They've also gone on to say that they had evaluated other sites, that they are following the Metro Act, and that suggestions have been taken into consideration. But one of the points made by one of the activists there, Stalin, very clearly asking why 80,000 objections that had in fact, more than 80,000 objections had in fact come in. Why was that not considered if the MMRCL is saying that suggestions were considered? A couple of things that the environmentalists also pointed out. One, the report that came out in 2015, which said that if the car shed area is concretized during heavy rains, Mithi River will overflow, in fact flooding other areas around International Airport as well. That is not just one report that's come out. There are other reports as well. There was this NESI panel that was set up in 2018, which very clearly said that land filling will in fact lead to further flooding, and that is happening, and it has already changed the course of the river. So there are multiple reports that have gone in, but to the point on why 80,000 suggestions have not been taken in, there was no answer. It seems But the government is hell-bent on going
Right.
ahead with the project. Towards the end of it, of course, MMRCL has said that they will go ahead with the car shed in Aarey itself.
Amita, many thanks for getting us those details. These are the big talking points that were in this town hall today. Let's take this to our panelists here tonight as well. We have Ms. Shaina NC, spokesperson of the BJP, Dr. Arun Sawant, who's former head of Environmental Science, Institute of Science. Thank you for being with us. First to you, Shaina. There have been many issues regarding this, 80,000 points being discussed against the construction here. We have seen other movements in the past, other green movements in the past as well in other cities where the governments have listened in. They have in fact cancelled plans despite arguing that this is in the name of development here. Why isn't the Maharashtra government listening?
So if you allow me honest 1 minute submission, I'd be really grateful, because all of us are environmentalists in our individual ways. I run an organization called Mumbai that my father started, which has only done one particular agenda, which is grow more saplings and trees across the length and breadth of Mumbai. We do know the survival rate of these are only 35%. Now, when we come to this particular metro, the Chief Minister of Maharashtra has said very clearly yesterday itself at the MAN program, where he says that every tree cut pains him, because the reality is that we have a lot of cases of misconception and false demeanor. The reality is this case has gone right up to the Supreme Court. The Supreme Court has said Aarey is not a forest and development needs to coexist with the environment. When we say coexist, what does that mean? The 2,100 trees that we're talking about, which are being chopped, are going to be replanted to the tune of 13,100, not as saplings, but as trees. The carbon emission that we are talking about also on a day-to-day basis, like for example, I would have missed your debate right now. It has taken me 2 hours from Nariman Point to Baikala Ray Road. Now, you tell me, this kind of congestion where we ourselves are polluting the atmosphere and the environment, isn't the metro going to be a solution? Mumbai is bursting at its seams. The kind of infrastructure that we, or rather lack of infrastructure, we've had our poor citizens being moved out to Mahol. That itself shows you that there is so much paucity of space. Kanjur Marg is not a viable media, because there is a case and the honorable courts themselves have said that the government cannot avail of that. The reason why Ashwini Bhide and Mr. Praveen Pardeshi today interacted with citizens is not because we're sitting on a high horse, because we want to clear misconceptions. So there are a few points which have been raised. One is to reduce the traffic congestion on roads and traffic pollution in the city. It will reduce 2.61 lakh tons of pollution, which outweighs the damage done by cutting of the trees. We accept that the damage of the trees, if they were cut to be mitigated without using these techniques, there is a question. But the kind of technology and the kind of expertise that the Maharashtra government under Devendra Fadnavis has looked for is from world over. And Mr. Praveen Pardeshi made a very important point today, where he said it's not as if flooding is not happening now with or without. We have to contain that with larger solutions. We live in a democratic country, and the land got designated for the car depot. It was later challenged by the High Court. This is the Supreme Court of this country which has gone ahead and said, please go ahead. The floods that we keep talking about, we have to have a holistic solution for low-lying areas, like a lot of pockets in Mumbai, which cannot be attributed only to the metro. And the pollution level shown in Mumbai is so high that we need to bring it down, and that can only happen with the metro and the coastal roads. So I think, please, let's understand that the larger cause is that of a democracy where citizens are needing of better better facilities, and this kind of bursting of seams at its through lack of infrastructure is not a solution.
All right. China, we've heard all those points being raised on how largely this is for the people, this is for development. Dr. Sawant, are you convinced? Are you convinced with the responses coming from each of the concerns that while we're going to be chopping off these trees, there is going to be a replanting of double, triple the amount. We're going to be putting in more saplings as well. This is going to take into account pollution. This is going to take into account not necessarily flooding, but something that is required for the city, which is bursting at its seams. Has all of this been a convincing argument at the cost of the trees?
No, these arguments are not convincing at all. We are the people from science and technology, the scientists, and have been practicing environment and how the restorations can be done to the already damaged environment. Now, the Aarey is the green lung for the city of Mumbai. The development in all other countries, if we see, from Latin America to the Europe, nobody has disturbed the ecology for developments, If you take an Hudson River, there is no overbridge. The bridges, the passages are made beneath the rivers, underground. If you go to the Niagara, you travel miles, you will not see the bridge across. Now, the developed countries are not disturbing the environment and ecology. The Mumbai is a highly populated city with such a high density population. Aarey Forest National Park is the only green lung. I would say the Honorable Supreme Court has said that Aarey is not a forest. I would ask the petitioner that to make an amendment and ask for the review of the petition. If all kinds of species that you name, including tigers, leopards, and all kinds of birds and everything, that is what today our environment also has said, if they're living in that area and you say it is not a forest, then what it is? It is not yet urbanized. The Kolis and Adivasis have been staying there in the good
Can I make
harmony.
a quick rebuttal?
So,
yeah, right. Shaina, go ahead.
Cutting of
because
the trees.
if this has been turned down on the basis that Aarey is not
I just
forest
want to
land,
make a quick rebuttal.
Irrespective, at the end of the day, we are doing away with a part of our green cover.
So I just want to make a quick limited point. The Honorable Supreme Court said that this issue is about trees being cut on an area which is not a forest. This was the Supreme Court's finding. And what our Chief Minister said and what the petition of the state government was that the underground metro project would mitigate carbon footprints to the extent that otherwise we could require as many as 2 crore full-grown trees to be planted in Mumbai, which is physically impossible. So I think we don't need to correlate the two issues, but at the same time, we must understand what the Supreme Court said. Supreme Court said Aarey is not a forest. The state government said the carbon footprint that requires 2 crore trees, it's impossible for us to plant. So
all
right,
but my question here being, and Dr. Sawant, if you can address that based on what Shaina has just said, because the basis of this argument is, go ahead with chopping these trees because Aarey is not part of forest land. It's not designated as forest land. It doesn't require these hiccups as far as green clearance is concerned. It's a patch of green. It is believed to be the green lungs for the city. But because it's not forest, technically, you could go ahead and chop these trees. You're still chopping trees.
In this relation, if Aarey is not forest, the all colonies will build adjacent to the Aarey colony or the national park. Why the forest department objecting for those constructions, the building, they wanted to demolish them. So if it is not a forest, why 36G or other sections have been applied and people have been asked to demolish this building till the government intervened and got them regularized. And those buildings were not demolished. So if it is not a forest, why this action was proposed?
China, there's a bunch of petitions here which is going to be heard in the 17th of September – because the Bombay High Court Chief Justice has taken into account so many issues that have been raised regarding Aarey on why it has not been declared a forest to save the floodplain, the tree authority matter, the hurried manner in which the decision was taken by the tree authority, despite reservations that was put in by environmentalists who were appointed, a court-appointed tree authority. All of these issues are going to be taken up collectively on the 17th of September by the High Court. Do you think all of this is a futile argument? The one standalone argument that the government stands for is this is for the development and this is what we all need to take into account, irrespective of the risks or the costs involved here.
You know, today Nitin Gadkari was in Mumbai and he had a press conference and he made one pertinent point which I'd like to quote. He said, you take the example of the Bandra Worli sea link. More than 150 petitions were received against which, saying that there is, going to be all kinds of hazard to marine life, and the cost escalation was not even taken into consideration. So he said that if you want to protect the environment, it can be balanced with correct development. Trees that should be transplanted first and trees cut, they have to be substituted with 3 times the amount. Now, Sudhir Mungantiwar, as our forest minister, has planted 33 crore trees across the length and breadth of Maharashtra. So it's not as if there is any question when it comes to our intent, or rather suggesting that there's going to be some kind of misuse of power.
But these trees have not survived,
that,
China.
We do a disservice
we
to the
have taken into account the compensation that the government offers as well. 48% of those trees replanted have not survived. And this is a figure available.
The Metro Corporation is...
You're not taking into cognizance the kind of fuel emission that we anyway... Can I just make a limited point, please? Today, when Ashwini Bhide and
Dr. Sawant
had this press conference,
the Metro Corporation say they are ready with the samplings, but the kind of samplings...
Dr. Sawant, can we accept, Shaina, let me put this question forward to Dr. Sawant here, please. Dr. Sawant, can we accept the compensation that we are offering for chopping off these trees is to bring down the carbon footprint, to bring down the pollution by the construction of the metro? Is that true? Does the metro really pull down emissions?
No, first of all, for any development, chopping down 2,700 trees is a huge loss. The very old trees, over 100 years also, many of them, so they cannot be compensated, and they will... The new sapling, if they are planning, then where they shall plant it when the metro car shed is coming in that spot? All concretization. What will happen to the water flow also? So there is not going to be compensations of either CO2 reductions or oxygen addition. That we have all the calculations ready. That is one issue. Secondly, it is...
China, has the government identified land available for all of this replantation? Has the land been identified? Is the land available for all of these thousands of replantation that you're promising?
The preparedness of Metro Corporation to have the saplings to be planted.
So let's have Shaina respond to that, please.
Even we have some calculations, sir.
Shaina, go ahead.
Sir, if you have calculations, even we have some calculations. The total Aarey has 4.83 lakh trees. How many? 4.83 lakh trees.
Please
from which we require 2,700, which is reduced today to 2,135. One sec, sir. Sir, please.
And you say that's only 17%.
460 trees. And if we transplant 6 times, no, 1 second. And if we transplant 6 times there, in the same space, I don't see why there should be a question. 2,700 trees would have absorbed 64 metric tons of carbon dioxide per year. But we are losing that. Yes, if the Metro 3 is constructed, then the absorption will be 64 metric tons of carbon dioxide, which will be reduced in 4 days itself.
Dr. Sawant, can this work out mathematically? We're looking at figures here on how many trees chopped with respect to how many trees replanted, whether or not they're replanted in an area and a soil that suits them. Can we look at this mathematically? Can we do number crunching on this.
No, I do not
Dr.
agree
Sawant.
with this kind of calculations, because in terms of compensation, if the metro's preparedness is there, I have seen their kind of preparedness, the sapling they are preparing of Ashoka, polyelthelia, and that of mangroves. Mangroves cannot grow in that area, and Ashoka is not having that large canopy at all to compensate the huge trees of a natural origin of Indian trees. That this kind of calculation, if they have, they should have thought of other preparedness or preparation of sapling, which we have seen in their presentation. It's not. So there is no preparedness at all. Second, the calculations of carbon dioxide sink. The calculations are wrong. Sink versus the generations or absorptions of carbon dioxide and release of the oxygen. These calculations, mathematical equations, they have been not put or declared at all, which will want to contest them. Third thing, see, if there is respect for environment by the government or any organizations like, like this, so they would not have diverted the course of the Mithi River. Where are the calculations of those that the river's course is diverted, so there will be no flooding? If they have taken the
this is the reason why it has now become a citizen's protest, because there's no amount of convincing with the government here which is making sense in the argument that this is for the sake of development for the people. Dr. Sawant, Shaina NC, we appreciate you putting forth your points here and speaking to us tonight on this. This is a burning issue. This is something not just about a patch of land in Mumbai. This is something that every citizen would feel for. It's about the green lungs. It could happen in any city, any state. We were given the same argument. You remember very clearly, this was an argument that was given to us when trees were being chopped off, also to make way for the monorail in Mumbai. In the name of development, yes. In the name of reducing vehicular pollution, in the name of adding to public transport. Today, you have the monorail which is running in losses. Now, this is a live example in front of our eyes. No one uses it. And what have we lost? We've lost our trees. We've lost our heritage trees that were chopped off. We've also lost trees that were replanted. This is a formula that hasn't worked in the past. The government will have to relook into this. Let's now get you to the other big story. This is with respect to a statement that has been made by a very senior legal voice of our country concerning the sedition law. Supreme Court Judge Justice Deepak Gupta. He slammed the government machinery for liberal and excessive use of the sedition law. He said this while addressing lawyers at a workshop in Ahmedabad. Justice Gupta of the Supreme Court spoke at length about the sedition law and the freedom of expression. He said that no citizen should fear the law, adding that the sedition law is being misused to scuttle dissent. Undoubtedly, extremely strong observation here on this. Said that the right to dissent is one of the most important rights. Criticism against the government doesn't make one less patriotic. Take a listen. Okay, we're going to be playing out that statement in just a bit, but that is the crux of the issue here. Let's throw this open to our panelists. We have Mr. Sanjay Hegde, Senior Advocate of the Supreme Court, here with us. We're going to be having Mr. Siddharth Luthra as well, former Additional Solicitor General. Sanjay, first to you. This is once again raising the issue on, does India need to do away with the sedition law or amend it? Because time and again there have been instances here wherein which it is being misused.
Well, the sedition law is an anachronism. It came way back in 1870. It was a colonial law. It should have gone with the coming into force of the Constitution, which guaranteed the freedom of speech. Nehru, while speaking on the First Amendment of the Constitution, also thought that it should go, but he did not do anything about it. It's all Nehru's fault anyway. But after Nehru, every other government also did not do away with the law. In 1962, the Supreme Court construed the law, read it down in a way that made it constitutional. The Supreme Court said mere disaffection does not constitute sedition. That's what the judge today has again reiterated. It's only when there is an incitement to armed violence does this section come in. That was the gloss that the Supreme Court put on it to uphold it constitutionally. way back in 1962. Despite that, every government of the day continued to misuse it, and more importantly, every policeman who was charged with maintaining law and order and who thought that somebody was talking a bit too much decided that he might as well use the sedition sections and see where it went. To actually prosecute a sedition case, you need permission of the government. But to entertain a complaint, you need no one's permission. So you took on board an FIR, and because the section is now a cognizable offense, you could arrest. They start an investigation and wait for the man or woman to ask for bail. Arrests have happened. Arrests have frequently happened, but all of those people have got out on bail. And thereafter, the trial never happened. The trial never ended up in a conviction. The only major person we can recollect as having been convicted was Binayak Sen during the UP at the center and the BJP in the state of Chhattisgarh. Other than that, there has been no significant conviction. This is a harsh law which remains on the statute book and is used selectively against people who talk too much.
Okay. Mr. Siddharth Luthra, would you agree with that? Do you think this is something that is being used, abused against people only because it exists, it needs to be done away with, or does it need a revisit for an amendment?
Hello?
Mr. Luthra, is my voice going through, please?
Yes. Sorry, I didn't catch your question because I was patched in the middle. Tell me,
yes,
can I have the question
would you be in agreement with this? I mean, yes, this is a very strong statement that has been made by Justice Gupta here, that this has been existing since the British. It was used by the British against us during our independence struggle. And today it continues to be used by governments or local police against our own people. Why do we still have it?
Yeah, I think Justice Gupta makes a very reasoned and logical argument why the sedition law has no place in independent India. It is against the concept of freedom of speech, which is a fundamental right. It's an anachronism of the colonial era of the Raj. At a time when we had sovereigns, today the people are sovereign. And I think it's a fine, well-researched talk that Justice Gupta gave. I've had occasion to see the text of it. And I believe that his view holds good. I only hope that there is soon a challenge. And when such a challenge is laid, the other judges understand and appreciate the spirit with which these observations have been made. In fact, the observations which have been made, which are there for all to see. And when that challenge is laid, I hope the challenge will succeed.
Right, but Sanjay Hegde, how is the method and the process to go about it? Unless you have a government with the conviction that this needs to be relooked, this needs to be revisited.
Yes, governments rarely come up with that conviction because they think it's a vote loser. In very simple terms, the common man thinks that this law actually protects the nation against anti-nationals. We do need to get to a stage in our democracy where the common man believes that free speech is the most nationalist thing that you can have. That unless you have free minds and free speech, you will not have economic progress that comes with fresh ideas. Because a person who is not allowed to think and not allowed to speak will not come out with a fresh idea. That requires social change on our part. I believe that the Congress party, for instance, actually put scrapping of the sedition law on one of its manifestos, and then it faced quite a backlash from within the own within their own party. If the politicians don't do it, the question is whether the judiciary will. Now, the judiciary is faced with a 5-judge judgment of long standing, which has put a gloss on the section, read it down, and made it constitutional. Now, is that judgment to be overturned? To overturn that 5-judge judgment, you need the Supreme Court to be convinced first in a bench of 2, then in a bench of 3, then in a bench of 5. We refer it to 7, and then if those 7 overrule it. That also is a very long haul. The only way, to my mind, is if young India gets up and says, we've had enough of this nonsense. If young India gets up, the generation of Twitter and Instagram, the generation of social media, which says that we cannot risk a life sentence for anything that we type off in a matter of seconds and shoot out into the world, if that significant political constituency wakes up, then the politicians will be forced to respond. We cannot
Mr. Luthra,
bound our thoughts into narrow definitions of chauvinistic nationalism.
Right. Mr. Luthra, should this become a people's movement? Because at the end of the day, this is rather vague as far as Section 124A is concerned. Because if you have people, you have young voices, you have cartoonists, poets, writers, critics, journalists raising a question against the establishment, against the executive, against the judiciary, against the bureaucracy, or against the armed forces. This is very common to be slapped with the sedition.
Okay, I think we need to deal with it at 2 levels. While I appreciate Sanjay's viewpoint that there must be a public discussion and a debate, and young India must talk about it, but unless young India is in parliament or young India gets the people in parliament to change the law, it's not going to change. Secondly, the alternate method is the challenge, and while it may take time, I think that's the most plausible method because we are dealing with a 5-judge constitutional bench which has interpreted the provision. Thirdly, and which you need to appreciate, is that today the provision as it exists is being applied randomly, and if it's applied excessively, the remedy lies in the court. There are provisions which are often misapplied, and they may be harsh in nature, but then it is for the courts to strike down such application, whether on a challenge at the preliminary stage or at the final stage. And if you look at the judgments on sedition law, there'd be very few and far between which deal with instances such as journalists and others being prosecuted for sedition, and then people who make a public speech about something or raise a question, those kind of prosecutions rarely end up in a conviction. The difficulty really is, and this is something we need to have a checkpoint, and that's something which needs to be considered. How do we deal with overzealous investigators who invoke this provision indiscriminately? Today, unfortunately, the law as it stands does not provide adequate remedy for a malicious prosecution. It does not provide adequate recourse to a person who's charged. In fact, when people are exonerated, one of almost the standard advice that we give them is, now you've got your exoneration, now go home and forget about it. You do not want to necessarily, and most people don't want to go through a second round of the same proceedings when they file malicious prosecution or they claim compensation, and that process itself is the punishment. And that's a serious concern. So today, as we stand, the sedition law has been interpreted by the Supreme Court, and it is for the courts to ensure at the very earliest that there must be no misapplication. If at all, it has to be applied as it exists in the rarest of rare cases.
do we need someone sitting in parliament to do away or to challenge the existence of Section 124A? We saw this in entirely people's movement as far as Section 377 is concerned. We've seen it in other issues here as well. We don't necessarily need someone sitting in parliament. And if this is being slapped indiscriminately, irrespective of whether you're eventually convicted of the charge, you do end up spending a night or 2 or months in jail.
Yes, and that's what happens. You can invoke the section very easily. Somebody doesn't like something that I say, and then you go and file an FIR under 124. Because it is now a cognizable offense, the police are forced to register an FIR, and the police can at any time pick you up unless in the meanwhile you have secured anticipatory bail from the courts. Probably the one remedy, the lesser remedy, is to again make it a non-cognizable section as it originally was. Because if it's a non-cognizable section and you need sanction, then you don't necessarily need to be slammed into jail before the trial.
That's right.
If
so,
you have that,
Mr. Luthra, this is not about whether or not this leads to an eventual conviction.
Maybe you can strike a
It's about the
balance.
ease with which you're slapped with Section 124A. I mean, you have a set of students sloganeering, you have a set of students cheering for the Pakistan cricket team, you have a cartoonist making a cartoon which criticizes the government stand or a government scheme. It's about the ease with which it is used, because of which you're sent to jail. It's not about the eventual conviction or not.
If I may, I think what it really needs is the change needs, there is already sanction required before you can have a prosecution for sedition. But what it needs is a prior permission of a senior officer. For example, in organized crime, in terrorist activities, there are permissions required even before an investigation can begin. And therefore, the remedy, because this 124 is normally used with offences such as terrorist act, unlawful activities, and the ilk. Therefore, what is imperative is to provide for a high-level permission before it's registered. I'll tell you a simple, an old story. When before Shreya Singhal struck down Section 66A, I was the law officer. I was a law officer in the government, and the judges put a question as to what could be a safeguard. And the safeguard I had suggested on instructions was that let no FIR under 66A be registered without the sanction of the DCP, which is the Superintendent Police level officer. As a result of that, the prosecutions came down to a minuscule level till the provision finally was struck down. That can be an interim arrangement, and that is possible for the government of the day to do, because the CRPC needs to be amended. The CRPC can be amended, but there is also
possible,
a larger debate.
But it's not being done.
It's been around
Mr.
since
Luthra,
1870.
we're really looking at a very, very ideal situation here.
Okay.
No, Sanjay, if we talk about Section 66A, we talk about Section 124A, that there needs to be discretion before it is slapped against a person. We don't see that happening. If you raise the issue of Section 66A, which doesn't exist anymore, which has been struck down, mind you, there have been cases of people slapped, arrested under Section 66A, even 2 years after it was struck down. Sanjay, please respond to that. Can we rest back and think that the police or the government is ideally going to work along discretion before slapping the sedition law against you?
Well, in law, you are supposed to presume good faith on the part of the police and the government. But we all know that that is a presumption in law. It doesn't happen in fact. So the proper thing to do is to scrap this section legislatively. The politicians will do a thing only when it becomes politically convenient for them. You have to create the atmosphere where no politician can be seen as supporting 124A, or who says that 124A is not an anachronism and is necessary and should continue. Young India has the most votes.
Okay.
Young India
let's
is
get
the
in
one
more
which
voices.
is going to get, which
we
often
have one
gets
of our
most
viewers
affected.
calling in. Right. Mr. Srinivasan from Bengaluru here. Please go ahead.
Yeah, good evening, sirs. Good evening, ma'am. See, as a student of law, I stopped practicing law because of one particular section in almost every act. You will be shocked to find that there are two phases of the law for everybody. In every act, it says, one section, particular section says that any government officer under this act, under any act, will be deemed to have done something in good faith unless proved otherwise. But for the common man, it is just the opposite. And that has to change. This is from the British legacy, where they wanted to suppress the Indian natives. That has to change. Thank you.
And it's now being used against us. We appreciate you calling us in, sir. Mr. Luthra, quick response here to that. Yeah.
Quick response is that the good faith provision is put in to ensure that public servants are not harassed in the discharge of their duties. There are similar sanction provisions already in various statutes, and they've been continued. If it were not, no public servant in this country would be allowed to function. And this good faith provision has stood the test of time. The issue is different. The issue is really we need a more efficacious remedy when actions are not done in good faith. And frankly, the gentleman may want to look at the provision carefully. All these provisions provide for actions to be taken when it's not a good faith decision by a public servant, and you have a remedy under each such statute.
All right, Sanjay Hegde, quick response here from you as well. We were talking about good faith, but is this being used in good faith against people?
No, it definitely is not being used in good faith. The only faith that it is being used is that this is a draconian remedy, and if it is invoked, no matter how unjustly, the person at the receiving end is bound to shut up for more than a few days. The fellow will go on air in public, say something else, but he will stay within the realms of unbounded criticism. That is what the administrator believes. I should think that each wrong invocation must be met with fierce dissent, not only from the person charged, but from civil society as a whole.
Right.
Today it is Shaila Rashid. Yesterday it was Kanhaiya.
All right, I'm afraid.
Before that it was Asim Trivedi. Each of these people did not get the full public support that their cases required.
All right, so this will need to be a people's movement if people think strongly enough about this. If you're speaking out, you could be slapped with sedition. Is this something that we would need to fight for here? I'm afraid we'll have to leave it at this, gentlemen. Appreciate you being with us here on this discussion. The question that has been asked here on whether or not it is right to slap sedition under circumstances where you have students raising slogans, under circumstances if you have a bunch of students supporting the Pakistan cricket team. Yes, that has happened in the past. Or you have a cartoonist, or a poet, or a singer criticizing a government. The sedition law, which has often been described as a colonial era relic. Is that how it should be treated? A relic against the freedom of expression. In other news, a ray of hope, a positive update that came in regarding Chandrayaan 2. An unnamed official dealing with Chandrayaan 2 mission, informing the news agency PTI that the lander did land, but it made a hard landing on the lunar surface. Official said that the lander, which is in one piece, it hasn't crashed, but it is located somewhere close to one of the predetermined touchdown positions. The official also further went on to add that the lander is currently in a tilted position. Efforts are going to be on to make contact with it. Remember, it was to operate in a 14 days window of time. ISRO is going to be continuing doing that for the 14 days. ISRO, which lost contact with Vikram on Saturday morning, which was just 2.1 kilometers short of the lunar surface. We don't know if it had landed or not. Today we know, based on images that have been sent back, that it did land. It had a hard landing. It hasn't crashed. It is still in one piece. Let's get in more expert voices here on this. We have Dr. Ramesh Kapoor, former professor of the Indian Institute of Astrophysics, Also, Mr. Suresh Naik, who's the ex-group director of ISRO, chairperson, International Space Society. First to you, Dr. Kapoor, on this news here that has come in. As far as trying to re-establish contact with Vikram, is that going to happen in these 14 days?
In the next 12 days, actually almost 3 days are gone, and I think I must say that
yes.
11 or 12 days. One thing is that there is very little chance of its revival, and because it's in the tilted position as it has been stated. So that also disheartens us. Actually, we are hoping that it had landed on its legs, but it's right now possibly in the tilted position, going by what has been told us through the various channels in the country. Now, one thing is there. See, there are solar panels, so they are generating using the solar energy. They are generating power for the instruments that are there inside the lander. So we do not yet know whether the instruments are intact and are functional, or can become functional, because unless there is a signal from there, and of which the chances are being said to be quite bleak. So we do not really know, but one will only wish, and I'm quite an optimistic person. I think even if the probability is 0.001%, and we will still live with that, and we'll hope that in the next 12 days, even for one day, it comes back into life, and there will be sufficient and quite much of data with us. Of course, the Pragyan remains inside, because in this tilted position, as you can see in the picture in the back, only if it had landed legs down and was not yet was healthy, then only Pragyan would have been able to come out. So here, whatever few instruments are there on lander, in case they are able to function or they are functioning, we do not yet know, then some data should be possible. But as we know that there should be also backup electronics in case the signal is not being received and response is not being given. So that provision is kept. So here we do not really know, but let's hope in the next couple of days ISRO will come out with some definite statement. In the meantime, I also request that some of those images be released, please, because the whole country right now is citizen scientists. All of us want to do our own bit, and for our own little joy of discovery, even though your conclusions are going to be the final, so please give us those chances. So although I want to say that
certainly ISRO at some point would be releasing more details or images, of course, understanding how united the country stood at the time of when contact was lost. It was a collective emotion that each of us felt across the country. Let's in fact also take a listen in here. A remark that has come in from the director of Chandrayaan-1, Mr. Annadurai. He's spoken here on this as well. Let's take a listen in.
Place where landed is nearly 5 kilometers away, the place from where we landed. But that place expected to be not conducive enough for lander to soft land. That's also in a place. So that means local obstacles possible. I think this is what yesterday also we talked about. So that may be stopping for you to communicate from the ground. How you located. Similarly, use the same line of sight channel to establish a communication to the lander. Now I think that attempt have to go. But this attempt will come if you're doing it. Opportunity is very limited. You cannot have continuous communication. We used to make.
Okay, let's also get in a word here. Mr. Suresh Naik with us as well. Mr. Naik, thank you for being with us here. Help us understand what are going to be the learnings from the lander, from the orbiter. It's a given, of course, that this has been a 99% success, 1% being that we've not had Pragyan rollout, we've not had the rover rollout and prod further on the surface of the moon. But the learnings on data which is still being studied and analyzed, or what has been received in this mission?
Yeah, actually, is your question is what is going to be the advantage of the data received?
Undoubtedly, yes, sir.
Is that the question?
Yes.
Yeah, actually, there are a lot of things which we are going to learn from this mission, which will be enormously useful for the future missions. For example, now as the data will be analyzed, we will definitely come to know after investigations why the communication channel failed. That is the first and foremost important information which we should get, so that in the future missions we will definitely avoid this particular hurdle which has hampered this mission. Secondly, we can definitely try to extend the operation period of our rover and lander on the moon. Namely, in this Chandrayaan-2 mission, we have the operation period limited to 1 lunar day, that is 14 Earth days. That is because the sunlight is there only for 14 Earth days, and afterwards during the night the cold temperature they won't be withstand. We can extend that period by incorporating a heater on the lander as well as on the rover, and that heater should be something like a nuclear heater, which is self running type. It does not require solar power for its power source, right? So if you include a nuclear heater in these two systems, then they will keep these two systems on for the 14 days night, right, on the moon.
Okay.
And then when again the sun comes there, they can again revive their work. So this way we can extend the period of operation of the rover and lander.
Okay, Dr. Kapoor, since this is also helping us as a nation understand the challenges of landing. Okay, yes, please go ahead. Regarding communication, yes.
Yes. Yes, you see, what I wanted to add to this is basically today ISRO is trying very hard to restore the communication system. So let us understand what is this all about communication system on particularly the lander. Now we know the communication channel between the lander directly with the Bangalore center is completely off. So let us forget about it. Now the communication channel which is hopefully available to us is between the lander and the orbiter. Okay. So now if you take the best scenario, then on the lander we should have, if it is looking intact, then we should have the transmitter, the receiver of the lander and the antenna of the lander intact and working, right? And then actually we have the window for the operation to establish the communication is limited, because the one thing is the view angle over the lander is just about, I think, half an hour or 45 minutes. I'm not sure about it, because otherwise it will be outside the view angle of the lander, right? And second thing, it has to revisit the exact spot over the lander, and that these both the conditions to happen, it may take 1.5 days or 2 days, right? So only ISRO can try once in 1.5 days or 2 days the communication establishment operation. And another important thing is
so that very clearly also establishes that perhaps receiving communication is possible. I'm afraid, Mr. Suresh Nayak, apologize for that interruption. Dr. Kapoor, thank you for being with us. We'll have to leave it at that, but you've explained this to us so well. And this is the reason why we as a country continue to stand together as far as Mission Chandrayaan-2 is concerned. There is still hope. This was a very positive update that came in, that we had a hard landing. It wasn't a crash landing. We have the lander which is still intact, because because it's tilted, it's lopsided, we've not had the rover Pragyan move out and prod the surface of the moon further. But undoubtedly what it has established, that this was a difficult mission. The very reason we've had no other global space leader attempt this, we attempted this, and we have already met with a 99% success. It has landed 5 kilometers away from the calculated spot, and it perhaps could still be sending a signal in 2 days' time if we're lucky, and the orbiter undoubtedly would still be giving the world new information of the lunar surface in the South Polar region. It is a wrap on the urban debate. Thank you for being with us.